to winning isn't easy. The get out of jail free card and a discretionary clause in a Sedgwick administered plan. This is the story of Ms. Brock. So, as I have repeatedly said in the course of this podcast series, is that you really need to understand the terms of the policy or plan, because that policy or plan will define for you things like the definition of disability, the definition of occupation, and it will explain to you the standard of proof. Do you require objective medical evidence? Are benefits limited to just 2 years for subjective medical conditions or mental nervous condition limitations? But one of the most important clauses in a policy or a plan is what I call the get out of jail free card, known as the arbitrary and capricious standard of review. Now, I want you to make no mistake about it. You are not on a level playing field with any carrier or administrator if the plan or policy has the arbitrary and capricious standard of review. The arbitrary and capricious standard of review is not what it sounds like. And here in the 11th Circuit, the standard of review is a multi-part step, but I'm going to boil it down to the three primary steps. First, the judge has to determine whether or not they agree with the decision. If they agree with the decision, you lose. If the judge says, I don't like this decision, the analysis as a practical matter goes on to the question of whether there was enough stuff in the carrier or plan administrator to justify that claim's denial. And this is where we start getting into the arbitrary and capricious standard of review. If the judge agrees with Sedgwick, for example, in this case, then you're going to lose. But if the judge says, hey, I don't like this decision and there's not enough material that justifies this decision, at least in the 11th Circuit, we go on to the question of bias. And that is, was that Sedgwick decision influenced by their role as the decider of the benefits and their role as the administrator? What happens here is, if the standard of review finds that Sedgwick's interpretation was in any way reasonable, it doesn't matter how much evidence you've submitted in the appeal, you're going to lose. So let me illustrate that. And remember, please, this holds true in any policy or plan that has the arbitrary and capricious standard of review. How it might be interpreted in your circuit, is a different matter by circuit to circuit. But in this case, Ms. Brock worked for AT&T in a sedentary position as a clerk, and she became disabled as a result of essential tremors and neuropathy. She filed a claim for short-term disability benefits, was denied, and on appeal, 2 liar-for-hire peer review providers opined that there was no objective medical evidence that she was disabled. And they attempted to talk to her treating provider, Dr. Kumar. Dr. Kumar never indicated in his medical records that she was disabled and noted that her symptoms were controlled with medication. Now, obviously, that's not very helpful when your physician isn't willing to address in your medical records your restrictions and limitations and note things that are indicative of or could be indicative of an ability to work. So ultimately, she files an appeal. That's denied. She files a lawsuit, and she claimed that Sedgwick's decision was arbitrary and capricious because it was only based on those liar-for-hire peer review doctors who never examined her. Now, this case found that Sedgwick's reliance on the file review standing alone was not arbitrary and capricious. The file review would be considered inadequate when it would be established that the physicians really did not review the full record or summarily rejected a treating physician's opinion without providing reasons for that rejection. Now, you have to understand there is no treating physician rule in an ERISA disability case. This arbitrary and capricious clause really gives a license to steal to the disability carrier or the plan. The court noted that the lack of a physical examination was not a determining factor as to whether or not the denial was arbitrary and capricious when the plaintiff, Ms. Brock, hadn't shown how the physical exam would result in a different decision. Now, I think this case might have been different if the physical exams, as reported by her treating physicians, showed objective findings that would corroborate her claim that she was disabled. But in this instance, her doctor never addressed that particular issue. So it was a very difficult road, I think, for Ms. Brock to prove that this decision was arbitrary and capricious. And as a result, the court upheld this denial. Are you beginning to see a pattern? Let's take a break for a moment.
Have you been robbed of your peace of mind by your disability insurance carrier? You owe it to yourself to get a copy of Robbed of Your Peace of Mind, which provides you with everything you need to know about the long-term disability claims process. Request your free copy of the book at caveylaw.com today.